Welcome to BizTV's Beyond the Brand. I'm Kelli Phillips. Bill Hulsey is with me today. Bill is a distinguished attorney with decades of experience in patent, intellectual property, and business law. His law practice has been helping clients in the South Central U.S. secure valuable intellectual property rights as they establish and grow their business. Stay tuned. We'll be right back with more Beyond the Brand. Our next guest is a distinguished attorney with decades of experience in patent, intellectual property, and business law. He's helped countless entrepreneurs, inventors, and companies protect their ideas and bring innovation to market. He's known for making complex legal concepts clear and practical, and today he's here to share his insights every business owner and creative thinker needs to hear. Bill, welcome to the show. And first, before we get started, Bill, if you would kind of give us your background, where you grew up, what life was like before you got into law.
I grew up in Memphis, Tennessee, and right after high school, I had my first job as an entrepreneur. I was part of the initial team that started the company called Federal Express in Memphis, Tennessee.
Wow.
I like starting things. And so I like starting with people who are starting things. So that's where I've spent my time. My undergraduate degree is in mathematics. I was a submarine officer and built the USS Jacksonville, grew up in the South. And I, after military service, became a top secret physical scientist doing technical analysis of what this Soviet Union was doing back in the days of the Cold War. But did that work, got a master's in economics. I worked for an organization called the Army's Foreign Science and Technology Corporation, where we looked at what the Soviets were doing. I reported it. And that reporting activity is similar to what we do in patents as we talk about what's new and why it's new. Went on to law school, graduated from Vanderbilt Law School, became the managing editor of the Vanderbilt Law Review, and started practicing law in Nashville. Practiced there until I realized that I really wanted to do something that was more technical than what Nashville could do at that time. Now, Nashville's plenty tech rich right now, but back then it was not. And so I moved from Tennessee to Texas and started with a very well-respected big Texas law firm. Stayed there until I actually felt like I could do enough to start my own practice, and started that practice in back in 2003. And since then, I have owned and grown my own law practice, focusing on patents and trademarks. And we have offices in Austin and Tulsa and Bentonville and Memphis and Birmingham and Jackson/Ridgeland, Mississippi. Mm-hmm. And Austin. And so we represent companies throughout what I call the Cotton Belt Delta region, and our service is to help them. I also have a certificate as an economic developer. So I've been doing economic development for a number of years. The most important piece I've done in economic development was as a fellow of the IC² Institute at the University of Texas. And so helping companies start with technology companies is something that I've done as part of my practice for all these years. Enjoyed it greatly, continued to do it, and that's what I've done.
Well, it sounds like with your work as an entrepreneur that you understand probably better than anybody the importance of trademark, but not only that, patents. Tell us how important those are and why somebody that's new into business really needs the help of a lawyer as opposed to just doing this online themselves.
What a great question. there's so many people on the internet who want to offer you the ability to file a patent on your own using a website or something. That is a huge mistake. And people do the same thing with regard to trademarks. Trademarks and patents are one of the most complex area of legal practice that there is. And the problem is that if you make a mistake with either one of those filings, you're not going to know that you made a mistake until a year or 2 or 3 years later, and that's just getting the right. They may issue the document, but if it's not prepared correctly, it's not going to be worth a whole lot. And then if you ever have to enforce that right, if it's not done properly, you're going to make a mistake. You know, you can, by analogy, you can own a piece of property, but if the deed to that property is not properly written, properly filed, you may think that you've got rights to that property, that real estate, but you only know it when you have to sue on it. Well, if it's not done properly, that's too late to learn that. And the best way to avoid that is to do it right in the first instance. And that's why you need an experienced patent and trademark attorney. And that's what we do.
Now, a lot of people may say, I really don't know if I want to bite the bullet. How much is this going to cost me? Can you kind of go through what the cost of those would be?
That's a great question. We try to do everything we do with all the cost up front. We try to do everything we do with a fixed fee. It's a set fee. So let's say you wanted to file a patent application. What we do is the first thing we do to keep you from spending money unnecessarily, we want to make sure that your patent, your invention has not already been patented by somebody else and you don't know that they file it. So the first thing that we do is file what we call a global patent novelty search. And that includes doing the search on all the patent databases around the world. There are 107 million patent documents that the world's patent offices have published. And when we do that search, we do that for a fixed fee. It's a fixed fee of $2,000, which includes the search, the report, and counseling to make sure that you understand the effect of that report and how that report lets you know whether or not it makes sense to further invest in the patent application. And so we do that search. The counseling after that we do for the application. What we typically do is pursue the provisional application because we only want you to do the things that you need to do in order to protect your invention. And if you file the provisional patent application, that's a document that you file it. It gives you a filing date, an international filing date for protection of your invention. It has a 1-year term. At the end of the 1-year term, or before the end of the 1-year term, you want to prepare your document so that it's ready for an examiner. The U.S. Patent Office has 12,000 patent examiners, and they're specialists in the different areas of technology that the Patent Office offers. And as a result of that, we want to make sure that the document is written as strongly and beneficially as possible. That's what we do with the provisional application. But within the 1-year period after you file the provisional, the next thing we do is want to prepare that document so that it will have the best reception by the patent office for the examiner who is a specialist in your area. Of the 12,000 examiners, the technology capability of the examiners, and these are engineers and scientists, some of them are also lawyers, but they focus on the technology and the way that when the application is filed, it's prepared and channels through the patent office administration so that the document gets to the most capable section at the patent office. Now, this is something that is really important in patent prosecution, is that you want to prepare the document so that it goes through as effectively as possible the right channels at the patent office. And if you do it right, you do it in the right way, as opposed to having like a judge on your work, what you end up and can end up doing, that's our goal, is to work with the examiners at the patent office and have the examiners be a team member on getting the patent. They're not going to let something go through unless it's properly done, but they will collaborate with us to make sure that the document is as complete and properly prepared as possible. And time again, we work with patent examiners who understand what we're trying to do, and we've been very successful in getting these patents through.
Bill, I've got lots of other questions. Will you stick around? We need to take a quick break, and then we'll come back and talk more about patents and trademarks. And we're back with attorney Bill Hulsey to talk more about trademark and patents. And Bill, I've got to ask, when is the best time to file for that patent or that trademark? Do you wait up until the day that you have it all done? Or is there a timeline that you go off of?
What we like to do with the provisional application, the thing about a provisional application is once it's on file, it's not published. Nobody sees it. You control when and who sees that document. And the phrase that I like to use with the provisional application is file early, file often. And the idea is if you file the provisional application and you continue to improve, which most inventors do, the fees for doing the provisional application, the legal fees, particularly if you're a small entity, and that's a person who has an income of less than 200 and something, 3,000, about 2,000, less than $200,000 a year. The filing fee for a micro entity filing in a patent application is $75. So the expense that you have with the provisional application is the time and effort to prepare the writing and the drawings. That's where we spend most of our time. And the time to file that application is when you have your best understanding of how to make and use that invention. So if we can have a writing, help you make a writing of how to make and use that invention, then you're ready to move forward. If it's just an idea and it hasn't been, the phrase we use is reduced to practice, then it's too early. But the thing that we can do in the early stages, even if you haven't reduced it to practice, by that I mean are able to write it to the point where a person having ordinary skill in the area can make and use the invention, we can do a search. By virtue of doing the search, you can learn what needs to be done because you'll see other patents in the process.
It seems like file early, file a lot is the best thing, but are there other pitfalls that entrepreneurs fall into?
Well, one thing is to keep the invention as confidential as possible until you file it. And even after that, if it's a provisional application, you want to keep that confidential. And the way you do that is you can let other people see it for sure, and you can offer the invention for sale. But the idea is to keep close watch on it because at that point on the provisional, that's all you've got. You don't have an examination. You don't have a non-provisional application. Once you have a non-provisional application and the indications are that you're going to have it issued, then you can be more public with the invention. But having a guarded exposure of the invention during the provisional stage is good advice.
Now going to after, once you have the trademark, the patent, what are some of the infringement issues that you deal with, and how should a company respond to those?
Well, okay, so that's a very good thought. So infringement is something that you want to be on the watch for. It's really important, but the thing is this: on your invention, only if somebody takes an effort to steal your invention do you need to worry about infringement. Because in large part, in the early days of having a patent on file and issued, the penalties for someone who infringes your patent are money penalties. And those include lost profits or royalty that they have to pay you for the invention. Well, until you're in the very early stages, you're not going to see damages of that type. But in the later stages, 5 and 10 years down the road, Patent infringement is very important. And so getting that understanding, making sure that you know the value of your invention. Today I'm working on a valuation for a product that is an agricultural product. And that's a very important stage. And the thing that we try to do is assign a money value to that invention, and getting that on file, getting that prepared and formalized is what we do. So if you can understand and keep an eye on the value of the invention, then that value itself is something that will help dictate the type of care you want to practice with regard to infringement and preventing infringement of your invention.
Let's talk trademarks for just a minute. A company can secure a trademark if a similar trademark exists in a different industry or class, correct?
That is correct. Think of the Standard plumbing. The Standard is a brand that is used in plumbing. It's used in a lot of areas, but the name Standard, as used in plumbing fixtures, relates to that industry. And Standard may also relate to tires, or may relate to clothing and apparel. It doesn't relate to the standard that you get for the plumbing industry. So making sure that your description of goods and services that you use when you file the application, you want it to be as broad as possible, but you don't want it to be so broad that it makes the application weak, and ultimately the trademark weak, and ultimately you have a significant challenge in getting it through the Patent and Trademark Office.
So what makes a strong trademark?
There are different classes of what makes a trademark. The strongest is arbitrary. You might remember years ago, I'm showing my age, there was the name Exxon was introduced as a brand for gas stations, for petroleum products. It was not a word that was in any dictionary. It was a created word. Funny thing is, I've taught patent law and trademark law for years. And when I did, sometimes 20 years ago, the Exxon mark was chosen because Exxon did research and found that there wasn't a brand that used two X's together. And one of my students said, well, what about Dos Equis? And so that's not what it was, but there wasn't a word that used two X's. But getting an arbitrary mark where it's not clear that there's any connection between the name and the product is the strongest. The next stage is what they call suggestive. Think about software. The name Windows, Microsoft used early. And what that was, it was a mark to show on a computer how, when looking at the computer looked as though you were looking through a window, because it was a graphical user interface that related to the way that prior to that, computers were only able to show text. And so when Microsoft adopted the trademark for Windows, it was a unique mark, but it was potentially descriptive, but it was suggestive. It was suggestive to the mark. It wasn't descriptive. It wasn't arbitrary because of the idea of having your computer look at it as a window like we're doing now, but that was the second most strong. And then there were suggestive marks, and then the weakest is one that's simply descriptive, which identifies a particular thing, like a chair or a table or something like that. The other area that can be a challenge is when a mark becomes generic, and that can kill a mark. Kleenex, for example, is one that has over the years had challenges to make sure that it was suggestive but not descriptive as to a facial tissue. So I've taught trademarks a lot over the years and helping clients get their trademark. Trademarks are really important because over time, if you file for patent protection early on, those patents are going to expire. But over time, your trademarks don't expire. You keep them up, you keep investing in them. You name the product, the trademarks expire, the trademarks don't expire, the patents do. And so having a strong trademark on a product is very important in commerce.
So real quickly, are there 3 things that every business should know about trademarks or intellectual property?
I think to put value on it, if you want to get into the marketplace, thinking about your patents first, because time is of the essence with the patent filing. Trademarks, you don't have to have a filing to begin with. You ultimately want to, but there's not an expense that you need to incur on a trademark. You just need to make sure that nobody else has that mark. If you don't file for patent protection within a year of getting it into the market, you can't. With a trademark, if you file it and time goes by and it gathers strength and recognition, you can still get the trademark on that. So that's something that makes sense. And then you have other rights. You have contracts that relate to intellectual property, and then you have copyright and other areas of intellectual property. So those are areas that you want to focus on depending on the product that you want to enter the market.
And Bill, how can folks get in touch with you if they have more questions?
Go to my website. It's hulseyIPlaw.com, and that's HULSEYIPLAW.com.
Bill, thanks so much for joining us today. We really appreciate your insight. Thanks for watching BizTV's Beyond the Brand. Be sure to subscribe to the BizTV YouTube channel, where you'll find full episodes of this show, a 24/7 live stream, fresh BizTV content, and a few surprises each week to help you stay inspired.